I start every one of these talks by saying nobody goes to law school to be a ditch lawyer. I didn't write down in high school my ambition in life is to be a ditch lawyer. In 1978, I was the youngest guy in the office. It's a firm in St. Cloud, Rinke Noonan, and we had 2 ditch files in the office. The guy handling them left. I was the youngest guy in the office, and so they put it on my desk, Stearns County Ditch number 7 and Stearns County Ditch number 32. As it turns out, it's the best thing that could have happened for me personally. I love what I do. A little strange. I'm amazed you're all here to even hear about drainage. I find drainage fascinating, but my job is basically, I travel around Minnesota. I'm basically a truck driver in a sport coat. Last week I was in Thief River Falls. I was in Slayton. Yesterday I was in Granite Falls. Monday I'll be down in Fountain, which is south of Rochester. And when you do that type of drainage work in Minnesota, it's always fun because number one, you're dealing with agriculture, and then number two, Minnesota has one drainage code, which I'll talk about, but we have completely different types of drainage in Minnesota. When I was up in Thief River Falls last week, up there they know what flap gates are. Up there, everything's a straight ditch, runs 10 miles from the beach ridge, goes to the Red River, and then flows north. When I'm in southwest Minnesota, they have no idea what a flap gate is. Tile is just starting to get into the valley over the last 5 years. When I go to southeast Minnesota on Monday, the fall in that area is so drastic that what we're doing there is trying to slow down the flow of water as it flows off the type of fall they have. And so what I'm doing across the state, and again, somewhat fell into it, is I represent, I don't know, 40 or 50 different counties, many watershed districts, and then lots and lots of drainage projects across the state, along with working on farmers who decide, well, I think I'll just run a ditch across that swamp. They usually get a call from somebody, and then I get a call from them that they've got some problems, a cease and desist. And so all those things work together with what I do. As you can tell, if I started in 1978, that means I've been doing it 35 years. In those 35 years, I've never been as busy as I've been in the last 3 years. And there's a number of reasons. It's kind of a perfect storm that has happened during that time. Make sure I'm doing this right. Again, I'm preaching a little bit to the choir, but it's this perfect storm of things that have happened over the last 3 to 5 years that makes my job and tile contractors, anybody dealing with drainage, quote, depending on how you look at it, the best years they've had in many, many years. Number one, we obviously have high land values. And with high land values, when whether you're going to put in $800 an acre of new drainage versus if your basis in your property is $2,000, are you going to go out and buy a $12,000 per acre piece of property, or are you going to justify spending some money to improve your land? And so we have that balancing going on about where am I best going to use my money. And with that high land values, obviously you need a return, and that triggers part of what's going on. Obviously high commodity prices, again, right now very good. They're down some now, but historically the last 2-3 years with those commodity prices and with input costs, with the commodity prices, seed costs, fertilizer costs, when commodity prices go up, those costs go up. They don't generally come down when commodity prices come down, so those input costs are going to be there. Probably the most important one is old undersized systems. Some of you know the history of drainage in Minnesota. If you look at the large drainage systems, particularly what are called county ditch systems, which I'll talk about, which means ditch and tile in those systems, they were almost all put in between 1903 and 1918. And I learned something, I knew one of the reasons was Minnesota had no agricultural future without drainage. And so there was obviously a reason there needed to be drainage at that time. But Warren was telling me in farm economics class, considered the golden era of farming was 1910 to 1914. I did not know that, but that fits right in with 100 years later why there's so much drainage going on right now. At that time, Farmers made a lot of money, as I understand it, between 1910 and 1914, and you see a huge number of historical documents when I go to auditor's office that says those were the years they were put in. So from 1903 to 1918 was a huge amount of drainage. From 1918 to the early 1950s, because of the Depression, World War II, there was very little drainage going on. Then in the 1950s, there was a huge, again, amount of drainage for two reasons. Those of you old enough to remember who Khrushchev was, Khrushchev came over from the Soviet Union and said, "We will bury you in wheat." The United States Ag said, "Like hell you were." And at that time, SCS paid 75% cost share. You were not a good American farmer in the 1950s unless you were installing drainage systems. The SCS designed them, paid 75% cost share. And I always think, somebody else mentioned it today, historical perspective is always important. What's going on in the 1950s, that was what's considered was the best thing to do. Doug mentioned it. What we're doing today, we think we're the smartest. Whatever we're doing is going to be the best. I guarantee you, whatever we're doing now, 25 years from now, as Doug said, what were they thinking when they were doing it at that time? So from the 50s, there was a great amount of drainage. Then in the 70s started the environmental pendulum. It had been very pro-drainage, and starting in the late 60s, and then I started in 78, came in the wetland and the environmental issues. And then that pendulum has been swinging both ways over the 35 years that I've been doing that. But all that historical is because these systems, our major systems, are 100 years old in the state of Minnesota. If you go to Morton County, which is Fairmont, Minnesota, they have 240 county drainage systems in the county that are all basically 100 years old. Most of them are tile. So forget the fact that do we need to improve them, do we need to enlarge them, they're 100 years old and collapsing. There is going to be, in that county alone, there's a potential of a huge amount of drainage work if all we were going to do was repair and replace those 240 systems. The issue then comes up, do we replace it? At that time, they were just trying to dry down pasture. Now with today's agriculture, size of machinery, pattern tiling, input costs, are we going to put that 12 or 14-inch main in again? Or, since we have to replace it anyway, it's blowing out all over the place, we're band-aiding it, are we going to improve it? That's what I'm dealing with now is, do we put in a 1913 system or do we put a 2013 system in? And across the state, the answer is, with the people I'm dealing with in agriculture, well, our trenching costs are about the same. You know, a lot of the costs are already there. We're not going to put in a 14-inch main. We're going to go to a 24 or whatever it is. The big difference also, when I started doing this in the late 70s, we never, because of economic reasons, we never looked at tile bigger than 18, 24 maybe inches. Otherwise, we went to an open ditch. I had 2 projects last week that were approved. The tile sizes were 48-inch tile at the lower end. That was not economically possible in the early 1980s, but now people are saying whatever it costs to avoid open ditches because of, again, you farm, many of you farm, you know the reasons why, but that's what I'm hearing. So whether it's an improvement or a repair, we are going to see a huge amount of work on tile systems, and then obviously they outlet into open ditches at some point, which again, need to have work done on them or be enlarged or improved. Wet conditions, Dave talked about the change in climate, the wet conditions that we've had over the period of time that I've been doing this. There's clearly a concern about future regulation. It is not the sugar beet trucks running me off the road anymore, it's the tile trucks running me off the road. There are piles of tile everywhere. I have no idea how many millions of feet are being put in, but you'd have to be blind not to see how much drainage is going on. And there, just like every question in life, there's 2 sides to everything. There are those that think we need more drainage, there are those that think we need to stop drainage. And clearly, the answer probably will be someplace in the middle, but there will be more regulation. There is absolutely, in my opinion, no question of that. Right now, tile drainage is exempt from the Clean Water Act, what's called point source pollution. If I have a factory and I've got a 48-inch tile or pipe coming out of it, I have to meet clean water standards. Ag tile does not have to meet those standards and are exempt from that. And again, if depending on open intake, some of the cleanest water, as I've been told, comes out of tile. But the issue eventually, again, I may not be practicing, but the issue will be there will be clean water monitors at the end of every large system. And if whatever you're doing increases nitrates or phosphorus, you will have to buy clean water credits just like you have to buy wetland credits. I'm not saying when that will happen, but in my opinion, there's no question that the regulations will get tougher and that almost everything in drainage in the last 100 years has been quantity of water. The next 100 years will have somewhat to do with quantity, but quality of water will be the next big issue that will need to be addressed. And agriculture is clearly owns most of the land. And again, as the gentleman said, there's all kinds of reasons. There's impervious surface in town. I happen to live in Sartell. My water goes off my yard someplace into a stormwater and goes to the Mississippi River. There's no treatment in between that I know of. And so what we're trying to get to is the point of clean water. Again, sometimes I sound a little preachy, but clean water is a positive for everyone. I've never heard a farmer ever say, yeah, I want to do this project because I really want to wreck the water on my property. I mean, that's stupid. Nobody's going to have that position. However, there's going to have to be, and I think it's working a little bit that way, of whether the issue is impervious surface in town or whether it's ag or whether it's roads or whatever it happens to be, it's in everybody's best interest, even though I'm very pro-drainage, to have as well-designed systems and as positive for water quality as at least possibly we can get. So there will be regulation and landowners, and I'm the preacher of that. If you think you have a project that needs to be done and you're going to say, well, it's kind of a bad year, I think 5 years, I'm going to wait 5 years. You can wait 5 years, but the project you do today will not be able to be done the same way 5 years from now. And so I've started more improvement projects in the last 3 years than the 32 years total before that, simply because of all these reasons and the fact that once one area of a county sees, oh, they did that improvement project, we just had a 2.5-inch rain, look at how their fields are draining compared to our old 1913 system. It doesn't take very long as you drive around to see the difference. Up in the Red River Valley where they're tiling now, I have many landowners up there that tell me they'll have 80s next to each other, one tiled and one not, and it's completely different with the yield and how it looks afterwards. There's reduction in conservation money. At one time, it was close whether on marginal land you would put it in corn and soybeans, tile it and put it in corn, soybeans, or put it into a conservation program. Now with commodity prices and land prices, it's not even a close, from a purely economic point of view, it's not a close call. I am a strong proponent that landowners and farmers are the best at it. Grandpa wanted that 30 or 40 acres kept the way it was, and I'm going to honor his by putting it into a program. So agriculture owns most of the land in this country. They're the ones putting it into the programs. But again, it's one of those factors for the sons or daughters that come back to the farm now. It's funny, they wanted nothing to do with the farm till it got to be $7 corn. Now that job in town doesn't seem so great, and they want to be back on the farm. And so those issues are going to be important. And again, from a straight economic point of view, and it's just the conservation has a hard time meeting it. Fortunately, a lot of people, for other reasons, are putting their land in the conservation program. And then finally, farmers have money right now in tax policy. It's not like we woke up today and said, Martin County Ditch Number 7 is old and undersized. They knew that in 1981 or probably 1955, but we didn't have all these things, and agriculture did not have money. Most of my clients are farmers. Most of them are friends. for 32 years, I'd listen every time they came in about how farming was terrible and they weren't making any money and you know, take this well, they're my friends of mine, but, and in the 80s and some of the other years, they were absolutely right. But if you farm and you have, respectfully I say this, if you farm and you haven't made money in the last 3 years, you should think about bartending school, because you're doing something wrong, at least the type of the clients that I deal with. And so they have the money right now. I had to give a talk out in Swift County, I can't remember what town I was in. There's probably 80 farmers there. I pulled into this ag place and I thought I was in a new pickup lot. I have never seen that many new Escalades. What happened to your old farm trucks? Are they parked someplace? I mean, it's unbelievable. And then obviously the tax policy. You're either going to pay taxes or put it into tile or put it into machinery. It's, again, kind of a no-brainer from what I know about it. So right now, well, I'll talk about it a little more. I had projects in the 1980s that were $50,000 projects, and we had armed deputies at the hearing, partly because it was Stearns County German farmers, and they hate each other anyway. But taking that aside, money was very, very tight at that point. Now I had 2 projects approved about 6 weeks ago in Morton County. One hearing was at 10, one was at 10:30. We did not have one question at the hearing. Both projects were over $1 million, and all the landowners cared about is how quickly can we get this project done. Because those I'll talk about how they're funded, but they're funded under assessments, which is basically at about 3% right now. That's basically free money to pay over the next 20 years. If you increase your yields, it's a no-brainer. And what a lot of what I'm going to talk about today is from an economic point of view. So when you hear me say drainage, 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 there's always how do we do that drainage, but from an economic point of view, generally every study at Iowa State, Ohio State, every place you do a study, you get the biggest return for good drainage. It's really not even close as far as where you get the best return. There's 2 different types of drainage I want to talk about. We have private drainage and we have public drainage. By public, and I'll talk about county ditches, but private drainage, there are literally millions of miles of tile and open ditches where in 1917, 8 guys got together. They're your great-grandparents. They all needed drainage. They went together, didn't put anything down on paper. They just agreed, we'll dig this ditch or put in this tile. Nothing in writing. Put that down, and that ditch is served well. The problem is, if you are part of one of those systems and you all still reasonably get along, but you don't have a drainage and maintenance agreement, if you've got 8 landowners and the 6th guy down, it's a tile or an open ditch, the tile collapses, the ditch needs to be cleaned out, you have absolutely no right to go on that landowner's property and fix that system. So it's kind of an either you pay me now or pay me later. We do private drainage agreements that are put on the abstract with absentee landowners, with trust land so much now. Spend a little money, it's almost a if you can all agree, it's almost a boilerplate agreement that can easily be drafted, and then you don't have to worry if they sell that property to somebody that wants to put it into a wildlife area or whatever. You have the right to maintain that system going across there. Again, the private systems are owned by the people that it crosses their land. They don't have a lot of formality with it, but what's amazing to me, again, I act like I know farming. I'm not a farm, you know, I grew up on a farm until I was 5 years old, so I don't think that counts, but it's amazing to me from when I first started doing this in 1978, when I'd go visit a client, they could tell me who owned and who farmed within 2-3 miles of their farm. I come out now and we pull out of the driveway of the farm, and it's the 40 across the road, and he says, I think I know who owns it, but I have no idea who operates it now. And I hear that all over the state. So this private, even if you still get along, who do you even contact if the tile needs to be fixed? You're not sure who's operating it. So again, that's a little bit of a sales pitch. If you're still getting along, it will be an issue at some point. Those private lines are old, and if you don't have a drainage and maintenance agreement on the abstract that runs with the land, and you say, I need to fix that tile across your property, if they say no, there's nothing you can do about it. Oops. Well, what happened here? Well, I don't know what happened to the rest of my... One thing I want to talk about quick, I don't know where it is. I didn't put the PowerPoint together. One thing I want to talk about real quickly is what is Minnesota's common law when it comes to drainage. Minnesota is what's called a reasonable use state. I get calls all the time. My neighbor installed a pump. Isn't that illegal? My neighbor, I've got an 8-inch intake. He installed a 12-inch line and it stops at the fence line. Isn't that illegal? Whatever it is, isn't that illegal? The first question I always ask, is this really a water problem, or did something happen at maybe it's in the, did something happen at a wedding 50 years ago and you hate your neighbor and you're just going to use Kurt to try and make your neighbor's life miserable? Grandpa hated the neighbor, Dad hated the neighbor. You don't know why you hate the neighbor, but Grandpa and Dad said you were supposed to hate the neighbor. If that's the case, I don't want the case. I've tried many, many jury trials of neighbor against neighbor. I hate them. I do not like trying those cases because even if you win, the client had to pay the attorney's fees. So I always tell clients when they call about their neighbor's done this or that, sounds like you got a possible case. Go get an engineer or a hydrologist, and if they back you up, then I'll look at the case. One of two things happen. If they're just trying to use Kurt to make their lives miserable, they won't spend the money with an engineer. If they do get an engineer, the engineer will either tell them you're wrong or maybe that they're right. If they're right, then we'll take a look at it. The last case I tried was two brothers who we went to a several-day trial about a drainage issue, brothers, and fortunately I won. I had the least crazy brothers. So I hope he's not here because my client, it makes a better story if I say he was least crazy. He wasn't at all. But those cases are out there. All of you have had neighborhood cases that have ended up that way. I've preached long enough on that. My opinion is you don't have to like your neighbor, but if the drainage works best by working together, work together on the issue. Still give them the finger when you're driving by in the car, but work together on getting the drainage issue taken care of. So the other thing about the reasonable use test means you can drain your property as long as you don't unreasonably harm your neighbor. The good news about that is the answer is never yes, that's illegal, or no, it's not. I bill by the hour. You can't have much of a billing if the answer is yes or no. Each one is a case by case, and it's always engineer, expert against expert. Was it a dry or wet year? It's always the same issues. Can you prove your damages? Did you actually lose a corn crop, or have you lost crop on that piece historically before your neighbor did anything? So so people call me and say, well, show me in the statutes where it says that. That is what's called common law. That's case law. That's based on trials and precedent of cases. Minnesota is you cannot unreasonably harm your neighbor. And the reverse of that is true. You cannot block drainage if it unreasonably harms your neighbor. So I favor retention and wetland restoration projects, but when Tom Wenzel or Al Kane, whenever they design one, they always have to design it to make sure that if they put a weir or a blockage in, and this guy's in the RIM or WRP program, that the effect stays on his property, not backs up on the neighbor's property who is not in the program. So all that goes into these particular projects. the reasonable use test across the state is something I'm getting more and more calls because of all the drainage going on. And partly, this is my opinion again, partly because of the fact that you don't have to live across from your neighbor anymore, you don't go to the same church, same school, you don't have to see your neighbor. You're an absentee or renter or something comes in, I can just come in and I'm just going to throw this tile line in or pump, and I'm not even going to talk to my neighbor. I don't know how many people call me and I say, well, they almost call the lawyer first because they know their neighbor's going to be teed off about what they're going to do, and I always say, well, did you go talk to your neighbor? You know, go talk to them first. Maybe you can work together till you can get to the point where the fall is enough where neither one of you is going to be harmed by what you're going to do. So it's with drainage, all this drainage going on, also comes a lot of these reasonable use cases, which again, I dislike neighbors suing each other. It's just a bad situation, but there's going to be more of it because it's again, preachy. $7 corn does bad things to some people. They're plowing down the inslope of the ditch, they're planting down the inslope of the ditch, they're causing erosion in the ditch, they're out in the township road ditch within the right-of-way. There's much more good things with ag doing well, because those of you that are farmers, nobody puts money back in the economy quicker than farmers do. They keep the money in the economy, but there are some bad things going on. And again, this is my preachy part with, we do have some young farmers that have never had bad times. And I don't want bad times for you, but they have a real different opinion than some of you older guys that went through the early 80s. Some of them, I even hear some of the older guys say, we maybe need a little correction just to let people know it isn't always like this. And it can get where you have to work with your neighbor a little bit more. All right, I want to talk about, so that's private drainage systems. Mainly Warren wanted me to talk about what are called county ditch systems. We have a drainage code in Minnesota, 103E, that Al talked about, that it's been in place for over 100 years. And this drainage code, we've made changes, some changes, but the basic structure of the drainage code has not changed in 100 years. And that's for what those systems governed by 103E are known as county ditch systems. It's a bad term. I wish we didn't call them county ditch systems, because some people think because it's Martin County Ditch number 7 or Renville County Ditch number 66 that the county owns those ditch systems. The county is simply the drainage authority. The drainage authority is the one that makes sure that 103E is followed. I represent drainage authorities all over the state, and I also appear in front of drainage authorities on ditch projects. I just did one yesterday in Granite Falls, which was an improvement of Branch R of Ditch 9. We were improving one of the laterals of Branch R of Ditch 9, and then we had to make sure that we follow the statute. The drainage authority simply acts as the banker and the referee. So that particular ditch system was all in Yellow Medicine County. Therefore, the 5-member board of the Yellow Medicine County Board was the drainage authority. They do not own Ditch 9. Ditch 9 was built in 1922, I believe. The people that own Ditch 9 are the people that were assessed for Ditch 9 in 1922, or that land that was assessed in 1922 owned that particular ditch system. And so if a ditch is only in one county, the county board is the drainage authority, unless it's been turned over to a watershed district that I'll talk about in a minute. If the system, by system, I'm talking drainage area, watershed area, if it's in more than one county, it's called a joint drainage system, and it's made up of board members of each of the counties. Martin County cannot tax into Freeborn County. You have to have a board member on that board so there's representation for the assessments. The one that I have next week is a 3-county. It's Meeker, McLeod, and Wright County ditch system. So we have members of each of those boards. And again, county commissioners have to take off their county board hat because they don't own the ditch. They just have a duty to make sure that the statute is being followed. We have 47 watershed districts in this state, and if you're going to do an improvement or a new system and there's a watershed district that covers that area, the petition has to go to the watershed district. Counties can also turn their ditch systems over to a watershed district under 103D. In Stearns County, where I'm from, I always wondered why there was no drainage work from about 1965 to 1980, almost been 60 to 80, and it was because the auditor hated county ditches. And if you showed up at his office and said, I want to do a ditch project, he said, get the hell out of here. And so there was nothing done for 20 years. So we have 4 watershed districts that cover parts of Stearns County. And in Stearns County, the board has decided, the county board has decided the watershed district might be a better place to handle this system. And so they've turned the ditches over to the watershed districts. In the Red River Valley, up and down the Red River Valley, are about 5 or 6 watershed districts. All the ditches have been, not most of the ditches have been turned over to Wild Rice Watershed, Joe River Watershed, Buffalo Creek Watershed, all the watersheds up and down the valley. What are the different types of projects that you can do under this, under your drainage code? Because all of you, not all of you, but most of you, you may not even know, some of you may not even know you're within a county ditch system. If nothing, no work's been done on that ditch system for years and years, you may not have had an assessment against you on that ditch and may not even realize you're part of a ditch system. In the 7-county metro area, there's still 106 county ditch systems. Some of those people with $2 million houses with their swing sets down by what they think is the creek is going to be surprised when a big drag line comes through there and cleans out that creek. So, but we have all kinds of different projects under the statute. One of the type of systems we have is a brand new county ditch. Let's say Stearns County's last ditch is, say, 66, and somebody wants to do a new ditch system, ditch 67. I am seeing a lot of private ditch systems, for the reason I talked about before, now petitioning to become a county system. I've got one in Turtle Creek Watershed, just finished what's called Deer Creek. That was about 20 miles long of a private system that actually had a written agreement. I've never seen one that big. Now we're doing Mud Creek down there. Those are private systems where the landowners are saying, we don't even know who owns the land. When it's time to get it repaired, we don't know who to talk to. We have trouble collecting people's share because they live somewhere else. We're going to petition to make it part of a lateral to down there. It happens to be JD 24. JD 24, those of you that know Albert Lea, just north of Albert Lea, is Hollandale. Hollandale was vegetable country. Hollandale Ditch 24 has a 80-foot bottom and is 50 feet deep. It's deep in places. It's bigger than most rivers. Down there, everything's peat ground. Everything's pumped over into the ditch from all the peat ground. They have what's called iron ochre down there, which fills in tile lines. So they're replacing, we have tile permits, dozens of them all the time because of increased need for drainage, number one, but also because of iron ochre, they're having to replace their tiles on a fairly regular basis. So if you're going to do a new system, all right, you've got 15 landowners on a system, and you decide, all right, I think we need to make it a county system. Then we've got a ditch inspector, then it's inspected every year, it's cleaned out, the assessments are made. We just know in the future, because again, I don't farm, but if I was putting $200,000 into pattern tiling, I'd want to make damn sure my outlet was good and was going to remain good. I personally That would terrify me to put that kind of money into a pattern system and not know that my outlet is guaranteed and have some rights to that. So with the new system, it takes a petition to the Drainage Authority, and the petition has to be signed by either a majority, 51% of the landowners counted by 40s that the new system touches, or 60% of the land. So what that means is if I had a new county ditch system and it was going to touch 10 40s, I would need 6 of those people to sign if each one was owned by a different person. If one landowner owns 6 of those 40s, that landowner alone would be a valid petition to do a new system. And we're starting to see more and more new systems, even though, and a lot of them are just taking over private systems, so that, and there's a number of exemptions under the wetland rules for public systems that are not there for private systems. Improvements, that's the one I'm seeing the most of. Improvements are, if I've got a tile line that's a 12-inch main 3 feet deep and I want to make it 24-inch main 4 feet deep, that's an improvement. A repair is putting it back to what it was in 1917. An improvement is making it larger or deeper. To show you how important drainage is and was in Minnesota, an improvement petition takes 26% of the land counted by 40s. And people that oppose drainage think that how can less than the majority start a drainage project? But again, I always tell people, democracy has nothing to do with drainage. I never take a vote at a drainage meeting. Drainage under county ditch law is governed by 103E. If I can meet the statute, if I can get 26%, and when I started this in 1978, we used to get 28%. Dumbest thing I ever did. That meant, what, 72% of the people, maybe we haven't even contacted. I never do a project now without having an informational meeting and let everybody know what's going on. They may not support it or even jump on the petition, but at least they won't hear the rumors in the coffee shop, because the drainage rumors in the coffee shop that I hear are so out of touch with reality that it doesn't even come close to the statute. So again, I've got improvement projects all over the state. Laterals are like a branch of a tree. If I've got ditch number 6 and I've got a private line going up here that outlets into ditch number 6, a lateral is making that a part of the county ditch system. That again takes 26%. Impounding or diversion of waters under 227. For the first 20 years I ever did this, I never saw an impoundment project in a county ditch system. I'd always like to go back to those guys that put it in 1917 and said, we're going to block the drainage and create an impoundment. Those guys would, again, historical perspective, they were doing everything possible then to get rid of water. The cases back in the early 1900s, water was considered the enemy. You could drain whatever you wanted because it was even a public health issue, and that's some of the wording in the statutes. So right now, though, we're doing a number of impoundment. And again, even though I'm pro-drainage, how are we going to simply use 1913 technology and just make it bigger? No. As Doug said and other people have said, we're going to improve drainage, no question in my mind. But how are we going to do it and do it that makes some sense? And again, in my opinion, economics drives everything. And so whether it works economically is going to be the big issue on how we do these. Everybody favors impoundments and retention. I've never heard anybody not favor them, as long as it's on their neighbor's property. At $12,000 an acre land, they don't want to give up any land. They want it on the neighbor's property for the impoundment. And so we're starting to see more of those. But the best project I've ever done was Blue Earth County Ditch 57, a real short story. Blue Earth County Ditch 57 there was a state road in between. The downstream had been improved in the 1970s. The upstream wanted to do an improvement. The downstream people said, over our dead body. It was a lawyer's dream because this side had a rich guy and this side had a rich guy. It's perfect. They would have spent years fighting, and I give them a lot of credit, and I give the county commissioner and drainage inspector a lot of credit. They met at the local Legion I don't know how many times and worked it out to where these people agreed to retention, two retention areas. So instead of a 0.1 drainage coefficient, they got a 0.6 drainage coefficient, which was still better than way better than they had. And then to make it even better, all the moons lined up right. These people, the project got $455,000 from LCCMR, so they got outside funding for the impoundment. It's one of the few projects where everybody walked out of the room singing Kumbaya. That never happens in drainage. You always have some people upset. The only other project I had where everybody walked out singing Kumbaya was the city of Vesta in Redwood County, and that's because the federal government paid for the entire project. Everybody thought it was a great project. So usually, one of the first ditches I ever worked on, I apologize for telling war stories, but one of the first ditches I ever worked on, we had 3 brothers who, yep, they were crazy. I can't say it any other way. And I'm a big guy, and I was bigger at that time and always thought I could take care of myself. They followed me from Sauk Center to St. Cloud on my bumper with a gun rack. I mean, they were on my bumper. I was never so happy to get back to St. Cloud as we got there. But we also, it was again a case where we had armed deputies on the contractor's machine when they went across their property. So you've all heard the saying, whiskey's for drinking, water's for fighting. And there have been case after case of angry people when it comes to drainage. Some people have the idea, they always call it your water and my water. I should be able to block all your water, and I should be able to drain all my water, and I should have a wall around my field that never has any water issues. That just doesn't happen, and those are the kind of issues that I get paid to deal with. Repairs, we have a great number of repairs across the state. We've got, with pattern tiling, we have so much head pressure into these old tile lines, they're blowing right out of the ground. Again, a lot of this old tile, when we can't send a camera up it, it looks pretty good unless you dig down and touch it. A lot of this old tile was hand dug in. Can you imagine with one I had last week was an 18-foot cut and had been hand dug. Some old timers said the same dirt was touched 12 different times getting it up. You can imagine how many whiskey bottles are buried on the bottom of those trenches. So, I've talked about what each of these is, and again, it's all in the material there. One thing I should talk about repair, a lot of the old ditches were dug 1-to-1 side slope. If you're doing it for erosion control, you can flatten out those side slopes. And almost every system we do now, we never do 1-to-1 side slope, even in firm soil, but most of them are a minimum of 2-to-1 side slope, and we do that as a repair. What I want to talk about is finally, before maybe some questions, is how do you do, because literally we have thousands of systems in this state that need to be improved or something done to them, but nobody actually knows what to do or knows how to get the ball rolling on how to get something done. This is on that single sheet on the other side of what I handed out. This is the way I do them, just for your information. I never start a project without an informational meeting. A lot of times I'll get a call from a tiler, and a tiler will say, I'm working in this neighborhood, it's Pope County ditch number such and such, we're doing some tile, we know that the outlet is not adequate, the landowners are interested in maybe looking at an improvement project. But nobody knows really how to get the ball rolling. What I tell them is if you set up an informational maybe at the township hall or whatever it is. Nobody's committing to anything. It's just an opportunity. I always usually come with one of the 3 or 4 engineers that I work with. Again, if you're going to get an engineer working on any project, make sure they're a drainage engineer. There's all kinds of different engineers, but because you can build a building doesn't mean you know anything about designing a drainage system. So at that informational meeting, we go through the process. The engineer kind of looks at it. He's already usually looked a little bit ahead of time, and see if there's an interest. Sometimes at that informational meeting, the landowners say, no, I think we won't go any further than this. Most of the time they say, yeah, it's about time. Dad knew we should have done this years ago. It's not going to get any cheaper. The system's getting worse and worse. It's going to have to be repaired, whether it's this year or 5 years from now. And so if the informational meeting goes nowhere, there's a small charge we usually have for the informational meeting. Most of them do go on farther. And then any costs from this point on, including the informational meeting, if the project does go forward, is a cost to the total cost of the project, and will ultimately be a project cost. If the group decides to go ahead, then we do a petition. And again, the engineer supplies me. We have to say the starting point and the ending point of the project, whose property it crosses, what's their address, again, so that we know whether we got the 60% or the 26%. The petition is then submitted to the county auditor along with a bond. The bond is, and a lot of times now we're posting cash, like the one we did yesterday that we got established. The landowners had posted cash. They get their cash back now. What that is for, and the statute requires at least $10,000, what that is for is if we put $8,000 worth of engineering and legal costs into it, and then the project doesn't go, the petitioners are responsible for that $8,000. There's never a 100% guarantee, but the engineers I work with and myself, we pretty much know if the project's going to go before we even start it. It's submitted to the county attorney. The county attorney checks to make sure we have the necessary signatures, and they appoint an engineer. They usually appoint the engineer that we've recommended. And again, I can name on one hand the 5 engineers that I would recommend in this state that know how to do this process. The engineer does a preliminary engineer's report, and he has to answer 4 questions. Is the project feasible? Is it practicable? Have the environmental issues under 015 been addressed, such things as will it affect groundwater, will it affect wildlife, those type of things. And the most important one is the outlet adequate. That's going to be the big issue in the future, because I'll be the first to admit, no one individual project probably makes the outlet not adequate, because the project we had yesterday, the impact was going to be a 2% increase in stage flow downstream. And it was going to stay within the ditch banks, and so the engineer could legitimately say the outlet was adequate. But in some places, I've got 10 projects going to the same outlet, or same general outlet. When you have the cumulative effect of those, there is an impact. I'm a strong believer in drainage, but I'm also a strong believer that I shouldn't be able to take my 80-acre of water problem and simply transfer it downstream and make somebody else their 80-acre of water problem. That's why we're going to have some conservation drainage. We're going to have some retention. We're going to have to do all of that. The problem is, as Doug said, we're not quite sure what works and what doesn't work, but the flip side of that, my clients, or some of them are saying, yeah, you're absolutely right, Kurt, but let's get our project done first. So the next people can worry about how to do that type of stuff. So then the engineer does this preliminary engineer's report, then it's sent to the DNR for a DNR advisory report. If it's not protected water, it is strictly, you don't need a DNR permit. It's strictly an advisory report. And most of the pure ag systems, the DNR doesn't waste their time sending in a report. Because for years they would send in these boilerplate reports. We kind of didn't even take them serious. Now if we get a report from DNR, we at least look at what their concerns are. The one I have coming up in Watonwan County, the issue is the ditch is also protected waters, and under protected waters, we have to, instead of the 16.5-foot buffer strip, we have to have, under the statute, we have to have a 50-foot buffer strip. And so there's those type of issues. Then there's a preliminary hearing, and I'm doing a lot of preliminary hearings now. The engineer gives his report, and whether he answers those 4 questions. And it's almost always everybody singing Kumbaya at that point. You know why that is? Nobody knows what it's going to cost them yet. At that point, it's simply, have you met the statute? If everything's a go at that point, then they appoint the viewers and tell the engineer to do a final report. Those of you that know what viewers are, the statute says they shall appoint viewers. It doesn't say what the qualifications of a viewer, it says the Drainage Authority sets the qualifications. There's a Minnesota Viewers Association. The big, and I'll tell you kind of a timeline here, but the big holdup on projects right now is viewers. There are 3 viewers appointed. We only have about 4 or 5 lead viewers in the state. Morton County, with 240 ditch systems, has ordered redetermination of benefits on all 240 systems. That ties up a viewer team for years and years and years. So I was in Murray County last week. We appointed viewers. We'll be lucky if their viewing report is done in 24 months. That's the huge hang up right now. The viewers go out and determine who benefits from this improvement. And they look at what the system is now, they look at soil types, they look at drainage coefficient, they look at proximity factor, they look at a number of different things, come up with what looks like a complicated report. They look at A, B, C, and D land as to what your share is. And your share of the total benefits may be 7%. If all the land you own is 7%, then you'll pay 7% of whatever is spent on that particular system. The golden rule of drainage is that you cannot ever establish a project if the benefits don't exceed the cost, which makes sense. If the cost is going to be $450,000 and the viewer says there's only $300,000 of benefit, you would never do that project. But now with high commodity prices, that's really not an issue anymore. We always have way more benefits than we do cost. So right now, because of the shortage of lead viewers, the Minnesota River Board, which is made up of, I don't know, 14 counties, they're helping fund a viewers class at Ridgewater College. We're trying to train more young viewers. Any of you that farm and have some time, it's not a full-time job or doesn't have to be, and you have some interest in it, we need younger. To show you the average age of the viewers, I'm considered young. So it's an older group and we need some younger people in that. Then once we get the viewers report and the engineers report back, there's a final engineers report, a final advisory report. Then there's a final hearing. And again, we just did 82 in Murray County last week. We met all 6 requirements under the statute. They ordered the hearing. They established the project. There's a 30-day appeal period. You can appeal whether the process was done right. Hopefully, if I'm involved, that's a court trial. I don't have any of those appeals because hopefully we followed the process right. But if you don't like your benefits and damages, then you can appeal and have a jury trial on that. Then they award the construction contract, there's construction, and then there's an acceptance hearing to make sure they picked up the rocks and did all those type of things. Some of the issues we're going to face in the future real quickly. I hope I'm not boring you. I find it, but I'm starting to think, I got to stop here. Redetermination of benefits. If your project was done in 1913, there was an assessment roll done in 1913. You pay, if your 40 paid 7% in 1913, you pay 7% of every dollar forever. Well, those 1913 reports, I can guarantee you, are not fair. First of all, they don't have all the land that drains in now, so a lot of people aren't paying. And secondly, back in 1913, they only assessed wet acres. If you look, no old maps, that swamp grass looking stuff, that's the only acres So sometimes now the people that are paying 23% of every dime spent are down at the lower end. Their land is wetland. Under Swamp Buster, they can't convert it. They pay the most and they're getting the least benefit. So you can order a redetermination of benefits to go out and bring to up to date standard. Eventually, every ditch will be redetermined in this state. The issue is redetermination requires that then you acquire the one rod grass strip on each side of the ditch. We have a ditch in, I think it covers part of Chippewa, Yellowknife, whatever it covers, 3 or 4 counties. It's an open ditch that goes about 20 miles. The cost of acquiring the grass strip on that particular system is going to be about $800,000 that landowners, some will get payments, some will, but they're still going, they still say we need to get this redetermined. Bridges and culverts, we've got a lot of issues of, we've got 100-year-old bridges and culverts that need to be replaced. If it's on a public road system, they have the duty to replace it. If it's a private crossing and it was part of the original system, we have to replace it, but only at its original width. And most farmers want it wider because of today's machinery. If they want it wider, they pay the cost of that increased width. Right of entry, I just had one where the landowner wouldn't let people on the land, so we're going to have to get a court order because the statute allows people to get on the land. Impoundments or diversions. Viewing the length of time. If you started a project today, let's say we got a petition submitted today, if you were lucky, the project would get built in the spring of 2015. Might be the fall of 2015. So it isn't something that happens overnight. If you have land that drains into a county ditch system, but you're not assessed into that ditch system and you're going, oh great, I get all the benefits and I don't have to pay for that system. Under 401, anybody in the system can say, shut that guy off, he's not paying in. You'd better wear a flak jacket if you go out there and try and shut off his drainage, but there's a method for them to petition into the system. A lot of the systems at the upper end, we're starting to do partial abandonments. Up in the northern Minnesota, they have all kinds of county ditches that were put in for timber, but have never been worked on, or that people don't even know what they are. They're starting to abandon those. One issue that came up just yesterday or the last couple months was DNR was not paying their ditch assessments. When they buy property, they buy it subject to the county ditch. And in some counties they were paying, some counties they weren't paying, some counties the wildlife manager was picking and choosing which one he would pay. I wrote to Commissioner Landwehr. He just sent me a letter yesterday saying they'd reviewed it and they've directed all their staff to get up to date and pay all outstanding ditch assessments. So DNR will pay their ditch assessments. Fish and Wildlife will not. Fish and Wildlife's federal. Fish and Wildlife under the Constitution does not pay local assessments. And so if Fish and Wildlife buys property, they don't pay any ditch assessment, which drives people crazy since their land is draining into the system also. So that's one of the things. A lot of where do all county ditch systems end? Rivers, streams, and lakes. Where are cities built? Rivers, streams, and lakes. Most county ditch systems, not most, many county ditch systems outlet through towns. City of Bird Island, their entire street storm system under every street was Renville County Ditch 66. And so we had, the farmers were going to have to pay if they did any work on Renville. So we transferred that part under Section 812 to the city. One quick thing and then I'll quit, just wetlands real quickly. There's 4 agencies you have to worry about with wetlands. Whenever I do a project, I try and get the agencies together. 2 of them are federal and 2 of them are state. When somebody calls me, they said, the government's been out here, and I'll say, who? They say, the DNR. And I'll say, are you sure it was the DNR? It's almost never the DNR. But everybody thinks it's the DNR. DNR only has jurisdiction over protected water courses, which are type 3, 4, and 5, or protected water courses, and protected wetlands, which are 10 acres or more of type 3, 4, and 5. So they're larger, even Kurt Deter thinks is a wetland. And so if it doesn't come under their, if it's not one of those things, when we hold the meeting, we say to the DNR, thanks for coming, you don't have any jurisdiction. Then NRCS is the big player under Swamp Buster. Unfortunately, under privacy rules now, they'll tell us on a project, you've got some wetland issues, so we'll say, fine, where are they? They say, we can't tell you. The landowner has to sign a privacy to release it. It's a catch-22. We want to address the wetland issue, but they won't tell us where they are unless we get an authorization. So the first one's state, the second one's federal. NRCS is not a permit. If you don't want to be in the farm program, Swamp Buster is meaningless to you. The third one is in 1991, the state passed WACA, what Les was talking about, a state wetland law. And the fourth one, which was involved in the 1980s, but then was gone for about 20 years and now is back with a vengeance, is the Corps of Engineers. The Corps of Engineers are going to be a big player when it comes to future of ag drainage. So I think I'll quit there. I hope I didn't, thanks a lot. I hope I didn't bore you too much. So thanks.
We do have time for a question or two if you want.
Sure, absolutely.
Kurt, when they do a redetermination, the benefits are going to change, but does the actual assessment overall for the landowner
change? His question is, if you do a redetermination, the land value's gone up, so the big number goes bigger, but does my percentage actually change? If all the land was originally in, it probably doesn't change significantly. But the one ditch 9 we had yesterday, there were 11,000 acres paying, and when they do the redetermination, it's going to be 47,000 acres. So that one will change dramatically. Some people that are paying 17% now will probably go down to 2% of the cost or something. So depending on the system, redetermination isn't for every system. That's why you have to hold an informational meeting. I never have a drainage authority order redetermination because you're spending landowner money. I want to make sure we're getting a return for that. Any other questions?
Holes around a lake, how is their redetermination and assessment, you know, if everybody's got a quarter-acre lot and a half-a-million?
Question is lakes or municipalities, the viewers, and that's why you need experienced viewers. When it comes to lakes, they have a process, same as roads, railroads. They have the process they go through is how is it better? Does the ditch provide a stable lake level, and that's worth so much for value? For municipalities, they don't do it house by house. They do it, we assess Bird Island this amount of money, then how Bird Island spreads it out is up to Bird Island. So. Anybody else? Good, time to go home. Thanks.